Wait, please. Lord, we may be permitted to move an urgent petition on Monday. Actually, it was filed yesterday.
What is the matter about?
Matter is, my lord, what had happened, a promotion exercise is sought to be undertaken by the state government, PWD, whereby, my lord, promotees were engathered in the subsequent era sought to be made junior, and then selection process has started. Any day they might finalize it.
Monday.
It was
Wait,
filed yesterday, actually.
Wait, please, your lordship. Lordship, item number 37, lordship. We have challenged a rule, lordship, and it is before the division bench, lordship. So let it come after the division bench takes up the matter, lordship.
Mr. M.
For
Bhagavat.
the respondents here.
So it should be adjourned for?
Lordship, after that.
After Puja vacation, lordship.
After Puja, Lordship.
Mr. M. Bhagavati, learned counsel for the writ petitioner, as well as Ms. A. Verma, learned counsel appearing for the respondent 5, 6, 7, and 8 have both submitted that the connected rules are under challenge in a writ petition pending before the division bench. Therefore, full stop. Therefore, this matter be adjourned for 6 weeks. On the request of learned counsel for both the sides, this matter stands adjourned for 6 weeks.
Much older. My pleasure.
My lord, I beg to mention item number 56, my lord. I seek adjournment for a day only. Any day next week.
You don't want to do it today, you want to do it on Monday, something like that.
Any day, lordship, because I'll be preoccupied in court number 2, my lord.
But we will be preoccupied for the next 3 weeks. What to do?
Lordship, any day, lordship convenient, only for the day.
On the request of item 36.
56, my lord.
56.
Hearing matter.
On the request of Mr. J. Gorvial and a counsel for the petitioner, hearing of this writ petition stands adjourned. List again after the ensuing puja vacation.
So not Puja, my lord, any day next week or 10 days, man.
Not before next week, not before this bench. After
May I
2
please,
weeks. You write
Minute.
after 2 weeks. Not before Nanaya, after 2 weeks.
May I please? My lord, item 39 has become infructuous because the petitioner has got the relief.
Item 39. It's a contempt case.
Contempt case.
Mr. M. Mondal and a counsel for the petitioner submits that his client has already got the relief and therefore the contempt case has become infructuous. Taking note of the submission of the petitioner's counsel, this contempt case stands closed. Consequently, the IS stands disposed of.
Developers.
May I please, the Lordship? Lordship, I beg to mention item number 52. Lordship, we have filed an affidavit in opposition. Lordship, I humbly pray the same may be called for.
Yes.
Deeply obliged.
May it please your Lordship. Your Lordship, there is a writ petition 3552 of 2024. Your Lordship, actually, by an order of this honorable court, the matter was supposed to be listed a week after the filing of the rejoinder affidavit. There is an urgency in the matter, your Lordship. If your Lordship may be pleased to list the matter on 18th of 18th.
Next week.
Next week, 18th.
Don't put the date. Next week.
Next week.
Next week.
Much up.
May it please. Lordship, I beg to mention item 38, Lordship, what has happened due to the amended rules, whether the issue survives or not, Lordship, there I have to take instruction. 2018 matter, Lordship. Lordship, may
Mr. B.P. Boral and a counsel for the petitioner submit that due to the intervening developments, he is required to obtain updated instruction from his client so as to ascertain as to whether the cause of action in this writ petition still survives or not. As such, a prayer has been made to adjourn this matter for 4 days. Prayer allowed, list accordingly.
deeply.
May I please, your Lordship? Lordship, I mention item number 50 and 51. Lordship, I have filed today affidavit, Lordship. Kindly adjourn the matter for
50 and
today.
51.
Yes, Lordship. Today I have filed affidavit, Lordship.
Let it come. We'll see.
After adjourn the matter for today, Lordship.
You are appearing for whom?
For petitioner.
It's a contempt case.
Yes, Lordship.
What affidavit you filed?
As per direction of this honorable court, I have sent a notice. Repeated.
So you wait. When the matter is called up, we'll pass an order.
May I please, your Lordship? But I pray for listing of a matter also from motion on Monday, Lordship. Lordship, the president of the society, Lordship, who has already crossed the age limit of 60 years as per the statute, Lordship, he has called for a meeting on 17, Lordship. This removal was also accepted and a resolution was taken by the board of officers to remove him, but he is not really in Lordship. Obliged, Lordship.
May I please? I am paying for listing on 2 contempt case, my lord. On next time.
Contempt case.
Yes, ma'am.
What is the urgency? After 2 weeks, after 2 weeks. After 2 weeks, right? After 2 weeks.
Lordship, item 40, Lordship, we have filed IA yesterday, Lordship, that may be called.
Item,
40, Lordship, 40,
you filed IA.
Lordship.
IA cannot be called like this.
Lordship.
Let the matter reach, we'll pass an order.
Lordship.
May I please, Your Lordship, I want to mention regarding listing of the petition of 2024. It was last listed in July, and the petitioner herein is a retired employee, and he retired 5 years ago, and he is not getting his
After
pension.
2 weeks, right? After 2 weeks in the memo.
My
Yes.
pleasure, Lordship. Lordship, I beg to mention for listing of a WBC matter. Lordship, it's a transfer matter.
After 2 weeks.
May I please, Your Lordship? Lordship, I beg to mention for item number 31.
Item number?
Item number 31.
Yes. What do you want?
Lordship, there is some difficulty on the part of the petitioner. Maybe a
Prayer of learned counsel for the petitioner, this matter stands passed over. Yes.
May it please, Your Lordship. Lordship, I beg to mention this writ petition for listing was last listed before a year.
After 2 weeks.
Published.
Lordship, I beg to mention item number
Oh,
36.
mention memos will write, I mention after 2 weeks, any day after 2 weeks. Any day.
Item number 36, Lordship.
Hmm.
It may be allowed to withdraw, Lordship.
Why?
Order complied with.
Right. Mr. L.R. Majumdar and counsel for the petitioner submits that the order of this court has already been complied with. And therefore the contempt case, this contempt case be closed. Taking note of the submission of Mr. Majumdar, this contempt case is hereby closed.
Obliged.
The matter of 2013,
Huh?
2013.
Huh.
Yesterday also it was listed due to paucity of time, it could not be taken up.
Yesterday listed in which court?
In court number 8, my lord.
So what do you want?
Well,
What order was passed?
my lord, it was not, no order was passed, my lord, it was adjourned, my lord. No, my lord, it did not reach, my lord.
You should have made a mention before the rising of the court. This can't be done.
Can it be listed
No,
in the
you
list?
have to mention it there. When the matter was in the list, somebody should have mentioned that please, there is urgency, please. You can't get this matter.
2013, my lord.
Sorry, thank you. Yes.
May
sir.
please, Lordship, I'd like to mention for listing of an IA also, Lordship, there's an urgency we have filed yesterday. Your
What is the idea? about?
For granting an interim order, Your Lordship. The petitioner has challenged the advertisement published issued by the APSC regarding the recruitment for scientific officer and junior scientific officer, Your Lordship.
Hmm. When is the last date of application?
Your Lordship.
When is the last date of submission of application?
We have filed yesterday IA, Your Lordship.
When is the last date of submission of application?
Your Lordship, the result is already declared, Your Lordship.
Hmm.
So there is a possibility of distributing the appointment letter, Your Lordship.
Hmm. So, you
So-
want that to be stayed?
Yes, Your Lordship.
Why?
Your Lordship, since the advertisement violated the statutory provisions of the government.
20th of
To Monday.
20th.
May I
No,
please, may I please, Your Lordship? Lordship, I beg to mention for listing of a petition on Wednesday for admission column, my lord. Matter pertains to my lord selection and appointment in the post of peon in the office of district and session judgment.
You write after 2 weeks. After 2 weeks.
Much obliged.
May I please, Your Lordship? Matter that I beg to mention item number 6, my lord. Can it be done next Monday, my lord?
It will be adjourned for a week. On the prayer of petitioners council, this matter stands adjourned for a week.
Obliged. May I please, Your Lordship? That I beg to mention item number 16, my lord, 16. May it adjourn for the day, my lord.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks.
My lord,
Oh,
there
1
is,
week, 1 week. It's a motion.
my lord, another prayer, my lord. There is a typical error, my lord. May I correct, my lord?
No, you can't. That's not permissible anymore. That you cannot just overwrite it like this. Then you have to withdraw.
No, one
It is not permissible because everything goes into the CIS.
Obliged. May please, Your Lordship. Lordship, I beg to mention item number 20, my lord. It adjourned for 1 week, my lord.
Why?
My lord, I am not keeping it actually, my lord, my lord.
You are not keeping your and so you have
Yes.
not come to court. That is the ground. On the prayer of petitioners council, admission hearing of this matter stands adjourned for 2 weeks.
Obliged, my lord.
May I please, Your Lordship? Lordship, I beg to mention for listing of writ petition, we have filed yesterday. The petitioner is the Gaon Panchayat Secretary, and there was direction from this honorable court to reinstate him within 15 days.
Two,
to reinstate the petitioner within 15 days. But without reinstating, the authorities are contemplating to initiate departmental proceeding. So Lordship, kindly matter may come up on Tuesday.
Wednesday.
Next
Put the date of Wednesday.
Supplementary list for withdrawal, item 57.
You want to withdraw?
Withdraw.
All right, Mr.
Liberty may be given. There is some technical defect. Liberty may be.
Yes, you are appearing?
Water resource, Lordship.
No objection.
No.
Mr.
Yeah, no.
And Learned Counsel for the writ petitioner submits that there is some defect in this writ petition, therefore the petitioner has been granted leave to withdraw the writ petition with liberty to file a fresh. Ms. J. Gogoi, Learned Standing Counsel, Water Resources Department, is present and does not have any objection. The prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty of prayer.
Daily list promotion, item 1.
May please.
Yes.
Not annexure 1, page 11 to 17, madam. Not investment number 3 and 4 not complied the order. Not may as per direction of by the Lordship Court, madam. Lordship Court make a direction to consider the
Disobedience of the order. Directions contained in the order dated 24/1/2024 passed by this court in WPC number 7114 of 2023. This contempt case has been filed. I have perused the statements made in the petition. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondent by registered post with AD within a week from today. Item 2. Anybody appearing in item 2? None appears to be petitioner on call. The matter stands passed over for the day.
Item 3.
I'm sorry, Mother, I did not hear item 2. I'm sorry. As a contempt matter, my lord, the suspension of the order of the petitioner was set aside by the order at page 9, my lord, it starts relevant. Page 12, paragraph 16, the order of suspension is accordingly set aside, has spent its force, and accordingly direction is issued to reinstate the petition. And
where is the direction to reinstate?
my lord, paragraph 16, my lord.
No timeline has been prescribed.
No timeline has been prescribed, but then, my lord, already more than 3 months have passed by, my 4 months.
All right, take on heart Mr. M. Kicharu and senior counsel listed by Mr. P. Bhavadar, Learned Counsel appearing for the writ petitioner, alleging willful disobedience of the direction contained in the order dated 8/5/2024 passed by the Learned Civil Judge in WPC number 1467 of 2024. This contempt case has been filed. I have perused the statements made in the contempt petition. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the sole respondent by registered. Yes.
Item 3.
Oh, yes. Who is appearing? Item 3. None appears to be petitioner or call. Matter stands passed over for the day. Well, then you write like this. None appears to the petitioner on call. The name of the counsel for the petitioner has also not been shown in the cause list. Register to look into the matter and list this case again by reflecting the name of the petitioner's counsel in the cause list.
Item 4.
Madly. This is a new contempt matter, my lord. I am paying a notice may be issued.
Page 42, my lord, relevant portion.
What is the relevant portion?
My lord, page 42, my lord, the above exercise is now required to be carried out by the Commissioner Panchayat and Rural Development Department Assam shall be initiated and concluded by the said authority within a period of 2 months from the date of receipt the certified copy of this order along with the representations so filed by the petitioners.
So it was to be done by the commissioner and secretary.
Yes, ma'am.
Why have you included all of them?
Because, my lord, they are also, my lord, not cooperating, my lord.
Then you implicate all the government officials.
That only, my lord,
All these 700 officers you implicate
only,
them.
my lord, director may be issued.
Huh?
Only, my lord, director may be issued notice.
Director may be issued notice.
Other may be ignored, my lord.
No, but why have you implemented them?
Then
Either you implicate all the officers of the
other
state,
may be, my lord, stuck off, my lord.
you make an application to strike it out. You have to file amended cost title then. You file amended cost title, then we'll issue notice.
My lord.
Mr. A.M. Bovial and counsel for the petitioner submits that the direction of this court was on the commissioner and principal secretary to the government of some Panchayat and Rural Development Department. But due to a mistake on the part of the petitioners, the other respondents have been inadvertently added as parties numbers, added as respondent numbers 2 to 9 in the contempt case. First, requesting this court to delete the name of the respondent numbers 2 to 9 from the array of parties in this contempt case. Mr. Borbia has prayed for a week's time to file amended cost title. Prayer is allowed. The names of the respondent numbers 2 to 9 is hereby deleted on the oral prayer of Mr. Borbia. Amended cost title. How much time you need? Amended cost title.
Monday I will file my.
Amended cost title be filed within a week from today. Register to list this matter thereafter for motion.
Monday. Give me.
Yeah, please, Alkur.
Yes.
My lord, this is regarding compassionate appointment, my lord. My case has been rejected by the SNC, my lord. Case number 23, my lord, relevant portion, my lord. 23, third paragraph, my lord. The SLC considers, my lord.
So what is wrong with the SLC decision?
My lord, I have applied, my lord, within 1 year, my lord. After 2010, it, as per Procedural Nessa case, my lord, it is 1 year, my lord. And thereafter, my lord, there is no vacancy, my lord. Any other department, my lord, my case may be considered, my lord.
These are all dismissal in admission stage. We'll create a column. We'll dismiss it, but we'll trouble you a bit. Just obtain the instruction and after 10 years, there can't be compulsion.
Well, I have no fault, my lord. Earlier, I have already.
Whatever. Your fault is you should have come to the court in 2015. That is the fault. And that fault will be costly. We are not entertaining, but just to maintain transparency in the process, we'll issue notice. That's all. Third, Mr. F.A. Hospital and counsel for the petition. The matter pertains to
1 and 4.
grievance expressed by the petitioner for rejecting his application for appointment on compassionate ground. I have perused the statement made in the petition. Ms. M. Bhattacharya, learned Petitioner Senior Government Advocate Assam, and Mr. N. Upadhyay, learned Standing Counsel.
I'm for 2 and 4, Lordship.
Irrigation Department have prayed for some time to obtain instruction. You may issue notice returnable in 6 weeks. Since Mr. Upadhyay has accepted notice on behalf of respondent numbers 1 and 3, and Ms. Bhattacharya for respondent numbers 2 and 4, service of notice is deemed to be complete in this case. Extra copy of the regulation. Because
Oblige, dear Lord.
Oblige.
Everywhere. Before lordship, my lord, he was joint secretary, my lord. There was a recovery of money, my lord. Alleged to have been bribe money, my lord, from rupees 90,000, my lord. But he was suspended way back in 31/10/2022, my lord. Till then, my lord, but departmental proceeding was initiated in the month of April, my lord, after 3 months, 4 months, my lord. But nothing has been done as of today, my lord. It was kept in, though I filed my WS, my lord.
You get preliminary instruction next week. We'll have it on Friday.
Next week, yes, Lordship.
Mr. P. Kottagal and counsel for the petitioner peruse the statements made in the writ petition on the request of Ms. M. Bhattacharya, learned additional senior government advocate Asap. This matter is directed to be posted again on 20th of September 2024 for motion so as to enable the learned government advocate to obtain preliminary instruction responding to the allegations made in the writ petition. 2 extra copies of the writ petition be furnished to Ms. Bhattacharya during the course of it.
Lordship fixing on
20th, next
Lordship.
Friday.
Yes, Lordship.
You tell us what is happening.
Yes, Lordship. Deeply.
May it please, your lordship. Lord, the petitioners before the lordship, they were initially appointed as contractual laborers. Thereafter their service were discontinued, and thereafter they approached this honorable court. This honorable court, my lord, passed an order that if the regular recruitment process is initiated, they will be allowed to participate by relaxing the age and other qualifications, my lord. But thereafter, several recruitment process initiated, but no opportunity was given to the petitioners to participate in the regular recruitment process. In the year 2020 also, a regular recruitment process held wherein they submitted representation praying for allowing them to participate. They said that the recruitment process is already over. So repeatedly.
So it's not a direction in eternity.
No, that's true, my lord. But
2015, you get a direction, you sit over it. After 9 years, you come to the court telling
There
that
was
now
an-
please condone my age. You relax. How is it possible?
I may not have a very strong case, but the thing is,
No,
my lord,
but you don't need to have a very strong case.
but
You tell us, do you have a grievance?
since,
Case, you forget it. You don't have a case.
yes,
What can be your grievance in
the
this matter?
grievance is that since this
9 years you have been waiting.
in the
If you come, if you would have come in the next election saying that there is an order to relax.
yes, my lord, in 2022, when this subsequent recruit after the order of the first
No,
order
no,
of this,
since 29/9/2015, the court had passed the
in
order.
the meantime, there was another.
Let us see the order, please. Let us see.
The first order, your lordship will find page 41, and operative portion, your lordship will find page 46.
Yes. All right, so this was
Thereafter,
an,
they issued advertisement, my lord.
this was an order passed in which year? On
2015, my lord.
29/9/2015.
Yes.
So precisely 9 years.
Yes.
before.
Thereafter, they have issued an advertisement.
Yes.
Wherein, Miller, I submitted representation that allow us to participate. 2019, Miller.
Yes. What happened? Then what happened?
We prayed that you allow us to participate. Then they did not allow us.
Then you didn't come to the court.
Then again, I approached this court. Then this honorable court passed an order that do in accordance with the earlier order passed by this honorable court. That order, your lordship will find page 67. And relevant portion, your lordship will find page 71, my lord. Last. In the impugned order, their stand is that, my lord.
Right, please come to page 71. What is
Yes,
the last sentence?
In view of the above, it is provided if there is any regular recruitment process for the post earlier meant by the petitioners, those petitioners who have surpassed the age bar shall be entitled to apply offline
And those applications have to be considered in accordance with the observations made by this honorable in the judgment order dated so and so.
So apply offline.
No, they did not allow us,
File contempt.
they did not allow us, and they
File
passed,
contempt.
they passed the interim order saying that by the time the judgment of this honorable court, subsequent judgment of this honorable court came, the recruitment process is over, my lord. That is there, and they say that in future, in the recruitment process, we will allow. But several recruitment process was done after this, my lord. No, nothing has been.
All right, heard Mr. Ishkidar, my counsel for the petitioners, that is the amendment made in the petition. The petitioners are basically seeking an order for this, from this court for relaxing their upper age limit so as to participate in the future recruitment process meant for appointment of grade 3 employees, appointment of grade 3 employees, is it?
Grade 4, my lord.
Grade 4 employees under the ONGC. To notice returnable in 6 weeks. Petitioner to take steps. Who is your for? Ms. K. Pukul and its CBC has appeared and accepted notice on their response number 1. As such, no formal notice is required to be sent to the said respondent. Extra copy of the petition be furnished to Ms. Pukul. Petitioners to take steps for service of notice upon the remaining respondent.
Did you?
With pleasure, Lordship. Lordship, here, petitioner is working on as a grade 4 employee in the Reserve Bank of India. And initially, my lord, although there is no rule in the promotion.
Is a relief of this nature maintainable in the court of law?
My
What
lord,
you are seeking here? What is the relief you are seeking?
my lord, I am seeking in
Kumari Madhavi Patil decision you have seen.
my lord.
Have you read it?
No, my lord, that is regarding the reservation of the caste, my lord, determination of the caste. Here, my lord, I am relying on the basis of two judgment, my lord.
No, even validity of caste certificate is to be gone
my
into
lord,
by the.
no, my lord, here what happened, my lord. I am belong from the Deuri community. I am residing in Arunachal Pradesh. Deuri community in Assam, normally it is considered as a ST candidate. And Arunachal Pradesh is considered as a general candidate. I am appearing here as a general candidate, my lord, not as a ST, my lord. Therefore, my lord, I am saying that.
So what is the prayer you have in this?
No, my prayer is that, my lord, because, my lord, that reservation policy they have adopted, my lord. Subsequently, I got from the RTI, my lord. There are total 108 posts, my lord. By following the 100-point roster, my lord, only ST candidate 7.5%, my lord. But they have making 24%, my lord. Then after getting the RTI, my lord, this document is with my lord, with me, my lord. I will bring the honorable before this honorable court, my lord. Then, my lord, where my case is that, my lord, they have, my lord, advertised for 5 posts. Out of 5 posts, they have 2 posts kept for general category and 3 posts for the ST category, my lord. And out of 108 posts, my lord, that 24 reservation cannot be given, my lord. If my lord turn to the advertisement, my lord, that has issued, my lord, page number 34, my lord. Initially, my lord, this reservation has initiated on 3% basis, my lord. 97%, my lord, direct recruitment and 3% for reservation, my lord.
So recruitment process started.
Recruitment process started, my lord. Even they have recruited 2%, my lord, in general category. And still, my lord, that ST quota still vacant, my lord.
We'll issue notice, that's all, on both main and interim. They just heard Mr. P. Sekal or counsel for the petition. There is the amendments made in the petition. The petitioner is agreed due to earmarking of the posts to be filled up by STP.
ST, my lord.
STP, SC or STP?
No, ST, my lord. Only ST, that's not PNT.
ST category candidates, which according to the petitioner is in excess of the quota permissible under the law. The petitioner's counsel has also prayed for an interim order, directing the respondents to keep one post vacant in the category of this is a matter of departmental promotion.
Departmental promotion.
One promotional post vacant in the class 3 category of assistant. Issue notice returnable in 4 weeks. Petitioner to take steps for servicing notice upon the respondent by the instant post to vary.
My lord, may I pray for vacant of the one post? Because my lord, why I am insisting for this stay, my lord, if my lord go to the page number 60, my lord,
Prayer for interim relief will be considered on the returnable date. It is however made clear that any further promotion to the contested post granted during the pendency of the writ petition shall be subject to the further order that will be passed.
Yes, sir.
Attention.
May please your lordship. One of the petitioner of your lordship, my lord, says a state police service officer under suspension was arrested also. And my lord, a disciplinary proceeding has been initiated. Now, my lord, although she asked for certain documents, but documents were not given to her, and being forced, my lord, she has also filed the written statement. Now, by the imperial order at page 140, my lord, she has been summoned, my lord, to appear in the DP for recording her deposition. And my submission to your lordship is that, my lord, since the criminal case is also pending in respect of the, my lord, same allegation. At least, my lord, till the charge is framed in the criminal case, my lord, if she has to, my lord, disclose all her defense, she will be highly prejudiced.
But she has already filed written statement.
Written statement has been filed, my lord, but my lord, thereafter additional, my lord, documents and additional, my lord, witnesses have been also given. And that also, my lord, indicates that, my lord, she is not really, my lord, because the allegation is that there has been manipulation of marks. By manipulating marks, you have got the job. Now, my lord, supplementary document also shows that without even the manipulated, my lord, marks, if at all, my lord, she is within the zone of consideration, she would have got the appointment. That your lordship may kindly find that, my lord, page 136.
That's all right, but you are relying upon which decision?
My lord, there is a Supreme Court decision
Which one?
which says, my lord, yes, that although, my lord, both the proceedings can go on, but when, my lord, the things are my lord, allegations are identical, this is, my lord, stands in stands that, my lord, relevant paragraph will be, my lord, the principles laid down in earlier Supreme Court cases, my lord, cases have been, my lord, discussed. My lord, there are 4 principles laid down. Dear Christian, it's the same book. Paragraph 10, my lord. In fact, 2-3 earlier decisions have been discussed. There is no legal bar for both the proceedings to go on simultaneously. The only valid ground for claiming that the disciplinary proceeding may be stayed would be to ensure that if the defense of the employee in the criminal case may not be prejudiced, but even such ground would be available only in cases involving complex question of fact and law. Then, my lord, such defense ought not to be permitted unnecessarily. Then 4 is important, my lord. Departmental proceeding can go on simultaneously to the criminal trial, except where both the proceedings are based on the same set of facts and the evidence in both the proceedings is common. Now, my lord, in the my lord, departmental proceeding also, the person, the IO, has been now named as a witness. If your lordship, my lord, kindly comes to page 136. That is the, my lord, supplementary document 136. 135 is the communication, my lord. This is dated, my lord, 26/7. In context of the show cause notice, there is so and so, the following additional documents are proposed to be relied upon for proving the charges and allegations. Additional document, extract of report of SIT investigation, Dibrugarh PS case number such and such. And additional witness is, my lord, the person who is the, my lord, IO. And if your lordship kindly comes to the next page, your lordship will find, my
Where
lord.
is the summon? Where is the summon issued to your client?
My lord, that is at, my lord, page 140. They are taking this as a, my lord, criminal case, the disciplinary proceeding also. Subject summoned to the charged officer in connection with the departmental proceeding drawn up against her. With reference to the subject cited above, you are directed to appear before the Inspector General so and so in his chamber for recording your statement in connection with the departmental proceeding drawn up against you. Now, my lord, date was 12/9/2024, but my lord, subsequent to filing of this case, my lord,
Who's
that
the Inspector General of Police here? What role he has? He is the inquiry officer.
Presiding officer, presenting officer, lordship.
He
He is the presenting officer.
Presenting officer.
Yes, lordship.
Why should presenting officer
No,
record statement?
presenting officer, lordship, he have to present the departmental proceeding before the inquiry officer. And before that, lordship, the delinquent, the officer, he would like to.
Are you sure? We'll state the entire proceeding then.
Lordship?
You seem to be saying things from your own.
No, lordship, there is the.
How can the who is this person? Why is he directing the petitioner to come and record her statement? She will defend her case. You present your own case. Why should she go and record her statement? Why? This clearly says she is to come and record her statement. Record her statement under which provision?
Lordship.
Is he acting as a IO?
No, lordship, he is
Then-
acting as a presenting officer.
Presenting officer cannot record statement. And 12/9 is already over.
My lord, 12/9 is over, my lord. Now, after the filing of the writ petition, my lord, the date has been extended, my lord. No further date has been given. They have postponed it. Now, my lord, may I draw your lordship attention to
No, what I'm not being able to understand,
my lord.
other things do not really convince this court. Only thing is, why is this lady, why is she summoning the petitioner to record her statement? Under what? When the evidence is recorded for the witnesses department, then it is for her to come and record her statement, adduce evidence, or whatever.
Right.
Why is she being directed to come and record statement? What is the reason for that?
Lordship, I have to take the instruction.
All right, then we'll stay it for now. But Mr. MP Chaudhary and Senior Counsel is stated by Mr. M. Sharma and Counsel appearing for the writ petitioner. There is the amendments made in the writ petition. The petitioner herein is subjected to a criminal proceeding in the form of, what is the
My lord, criminal cases 936 of 2016, Dibrugarh PS case number.
form of Dibrugarh PS case number, arising out of Dibrugarh PS case number 936/2016. On moral, according to the petitioner, on the same set of facts, a departmental proceeding has also been initiated against her. First up, the petitioner is primarily aggrieved by the letter dated 5/9/2024 issued by the respondent number
3, my lord.
Respondent number 3, directing her to appear before the said authority for recording her statement in connection with the departmental proceedings. First up, Mr. Chaudhary submits that the respondent number 3 did not have any authority or jurisdiction under the law to summon the petitioner to record her statement. First up, on a pointed query made by this court, Mr. J.K. Goswami, learned additional senior government advocate, also could not appraise this court as to Under what authority of law the respondent number 3 had summoned the petitioner to record her statement in connection with the departmental proceeding? Full stop. It is tried that, tried that in a departmental proceeding, after the evidence is adduced on behalf of the department, it will be open for the delinquent to defend his or her interest by producing evidence if so desired. Full stop. Under the circumstances, on what basis the petitioner has been compelled to appear for recording her statement remains a mystery in the facts and circumstances of the present case. Until and unless there is clarity on the aforesaid aspect of the matter, the operation of the impugned order dated, impugned letter dated 5/9/2024
2024.
as modified by the subsequent letter dated 9/9/2024 issued by the respondent number
3.
3 deserves to be suspended. As such, issue notice returnable in 4 weeks. You are for all the respondents?
All the respondents.
Since Mr. Goswami has appeared and accepted notice for all the respondents, no further notice, no formal notice is required to sign in this case. Extra copies of the writ petition. Requisite in number is the furnished to the Department Council so as to enable him to obtain instruction. Out on the prayer of interim relief, having regard to the facts and circumstances of the case, the operation of the letter dated 5/9/2024 as modified by the letter dated 9/9/2024 shall remain suspended.
Highly obliged.
But this is not a stay of the departmental.
Lordship, that may be recorded, Lordship.
My lord.
It's not a stay of the departmental proceeding.
Lordship, liberty may be given, Lordship. Liberty may be given
On
to
that,
the
my lord, I'll
departmental
satisfy
proceeding.
your lordship, my lord, regarding stay, because my lord, other two accused persons, my lord, co-accused, they had approached this honorable court and there it has been stayed by.
Insofar as the prayer made by the petitioner for stay of departmental proceeding, stay of the departmental proceeding itself, the said prayer is kept open and shall be considered on the returnable date after the stand of the respondents is brought on record in the form of an affidavit.
Lordship, a date may be fixed, Lordship.
Is this matter again on 22nd of October? 22nd October.
Lordship.
23rd October. Make it 23rd. 23rd October. Or you want it on 3rd October? 3rd October will be better. Yes.
Lordship, 3rd October is better, Lordship.
3rd.
The petitioner had participated in a selection process. Thereafter, approached the honorable court. Honorable court had observed to give 2 marks. That has not been given. In a similar matter, notice has already been issued in another matter.
Notice may go, Lordship.
Mr. B.P. Vora, I have counsel for the petitioners. There is the amendment made in the petition. Mr. Vora submits that the matter pertains to selection of SPOs and similar petition being WPC number 4084 of 2024 is pending disposal before this court. Mr. J.K. Goswami and a government he has also confirmed the said position. In view of the above, issue notice returnable in 6 weeks. Since Mr. Goswami has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition, requisite and numbers will be furnished to the London Departmental Council so as to enable him to obtain instruction in file affidavit. Register to list this case along with WBC soil check. Deeply.
May I please? My lord, in this case, the husband of the petitioner was my lord, a government employee. Now, he retired in the month of March 2007. My lord, he was entitled to 2 financial upgradations under ACP scheme, my lord. But his name was approved, but the upgradation was not granted. Lastly, my lord, that notice was issued to the respondent, they sought 45 days time to, my lord, to do it. But my lord, more than 1 year already passed, my lord, they did nothing.
Notice was issued to respondent in which case?
Yes, ma'am.
Which case?
No, not pleaders notice. Not-
No, notice was issued.
You take down. Heard Mr. Jesse Gordon, counsel appearing for the petitioner. The petitioner herein is the widow of a deceased central government employee. Central government employee.
My lord.
Who has approached this court inter alia contending that her deceased husband had earned the benefits of 2 ACP schemes, but the pecuniary benefit was not extended to him, as a result of which the family pension amount has also been adversely affected. Mr. A.K. Goswami, Leonard CGC, appearing for the respondents, prays for some time to obtain instruction in the matter. NOM speaks. Since Mr. Goswami has accepted notice for all the respondents, no formal notice, extra copies, repeated in numbers.
Like.
Item 13.
May I please, your lordship? My lord, in this matter, my lord, with a very limited prayer petition across this court, my lord, and petitioner retired from the service in the year of 2018, my lord. Therefore, as per the new amendment, payment of gratuity Act is entitled enhance of gratuity. Then I prefer under section of the 7 of that the same was rejected. I preferred appeal, which is due to me, my lord. For the
Mr. Dekal, and counsel for the petitioner. The read petitioner hearing is a retired, who has retired from service as an employee who had served under the which authority was this?
My lord, Commissioner and Secretary, my lord, Housing Board authority.
Who had served under the housing board is before this court being agreed due to rejection of his claim for payment of gratuity for an amount of rupees 20 lakhs. First up, the department has accepted. The department has. It appears that the department has granted rupees 7 lakhs as payment of gratuity to the petitioner. Mr. S. Bora, Learned Counsel, appearing for the
1.
respondent number 1 and Mr.
TN4.
Mr.
I'm T.R. Gogoi. Respondent number TN4.
So and so appearing for respondent numbers 3 and 4, prays for some time. Open instruction in the matter, issue notice of motion returnable in 8 weeks. Since Mr. Bora has appeared and accepted notice for respondent number 1, Ms. M. Bhattacharya for government additional senior government advocate Assam for respondent number 2, and Mr. Gogoi for respondent numbers 3 and 4. Service of notice is deemed to be completed in this case. Extra copies of the written petition requisite in numbers be furnished to the learned department council. Thus to enable them to obtain instruction and file affidavit in this case.
Item 14.
Let the pension matter, my lord, the petitioner completed 20 years, 1 month, 9 days, my lord. One similar order is enclosed here, there's an annexure 6 page 21 to 20.
The examined will take up for disposal at admission stage.
My lord, only the thing is that we have to verify the facts, my lord. Where, my lord.
The read petitioner, who was originally engaged as a masteral worker under the Public Works Department, had superannuated as a regular worker with effect from 31/5/2007. According to the petitioner, he had completed more than 20 years of service and therefore was entitled to receive pension under the rules. However, by deducting 6 years of service from his tenure, the respondents have rejected the claim for payment of pension to the petitioner. First of contending that the case of the petitioner is covered by the decision of this court rendered in the case of Sangeeta Roy and others versus State of Assam and others. Third bracket 2019 bracket 2 bracket close GLT 805. The petitioner is before this court seeking a writ of mandamus. Mr. Ardhar Lanet, Standing Counsel PWD Assam, prays for some time to verify the claim of the petitioner and file response. Full stop. Similar is the prayer of Mr. B. Chakravarti, Learned Standing Counsel, Accountant General A&E Assam, appearing for the respond number 5. In view of the above, issue notice returnable in 6 weeks. Since Mr. Dhar has appeared and accepted notice for respond numbers 1 to 4, Mr. B. Chakravarti, Learned CGC for respond number 5, and Ms. M. Bhattacharya, Learned Additional Senior Government Advocate Assam for respond number 6. Service of notice is deemed to be complete in this case. Extra copy of the writ petition requisite numbers be furnished to the Learned Department Council so as to enable them to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing.
May I please, Your Lordship? Lordship, this writ petition pertains to non-payment of compassionate family pension to the petitioners, as well as, Lordship, releasing of other pensionary benefits to the petitioners.
The writ petitioners herein have approached this court with a grievance that despite being entitled to under the law, the respondents have denied the benefit of compassionate family pension as well as other benefits to them on account of the premature death of the husband of the petitioner number 1. First of Ms. A. Talukdar, Learned Government Advocate Assam, and Mr. Bhattacharya, Learned
Respondent 5.
Counsel for the respond number 5 have prayed for some time to seek instruction. Issue notice. Mr. D. Bhattacharya, issue notice returnable in 6 weeks. Since Ms. Talukdar has appeared and accepted notice for respond numbers 1 to 4 and 6. 1, 2,
3 and 6.
3 and 6. Mr. A. Chalia, Learned SC Finance for respond number 4, and Mr. Bhattacharya for respond number 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite numbers, be furnished to the Learned Departmental Council so as to enable them to obtain instruction facilitating disposal of the writ petition at this stage of admission hearing.
We are not getting any provisional pension also, Lordship.
They will have to get the instruction.
Highly obliged.
May I please? My lord petitioner, my lord, has not been, my lord, paid her salary from 1/1/2014, 24 to 14th August, my lord. And because, my lord,
Not getting salary since?
Since, my lord, 1st of January 24 to 14 August, my lord. My lord, kindly see, my lord, page 29. My lord, then my NOC was rejected by my respondent BTC authority, my lord, respondent number 4 and 5. But, my lord, initially I am from the BTC.
Petitioner is serving as a nurse. Petitioner is serving as a GNM nurse.
My lord, now promoted to, my lord.
Can you please tell what the petitioner is doing now? Just
Ward in charge, man.
Huh?
Ward in charge.
Ward in charge.
Yes.
Under which institution?
My lord, I am at present, my lord, working, my lord, Sonari, Sarajevo, my lord. But, my lord, earlier I worked, my lord.
No, present, where are you posted?
I am working Sonari, Sarajevo. My
Yes.
lord, my lord, my grievance, my lord, against my BTC authority only, because, my lord, they have, my lord, rejected the NOC, but, my lord, allowed to join me and work me at Mosalpur, Baksa.
So the notice has to go then. Why you are not paying? Huh?
I'll get the instruction, my lord. In fact, since that NOC has not been granted, my lord.
No, but then we'll then post it for motion.
Lordship, I'll get the instruction, lordship.
How much time you want to get the instruction?
After 10 days, lordship will post it, my lord. In the meantime, before the vacation, I will get the instruction, my lord.
The salary is
That particular period, my lord. You know, 8 months or something.
I take down. Heard Mr. S. Chauhan, Counsel appearing for the petitioner. peruse the amendments made in the petition. The petitioner claims that she's presently serving as ward in charge under the ward in charge under
At present, my lord, Sarajevo.
and posted Sarajevo what? Bus stand.
My lord, Sarajevo district, my lord, under joint secretary, Sarajevo district.
Joint Secretary of what? Health and Family Welfare.
Yes, yes.
Huh?
Joint director, my joint director.
And presently posted as ward in charge. Uh, how can it be a ward in charge in some hospital? It has to be, na? 5 times I have asked this question, he is unable to give.
Udalguri Civil Hospital. My lord,
Udalguri Civil Hospital. The grievance of the petitioner is that for no fault on her part, the respondents have not paid her salary for the period since
1/1/24.
1/1/2024 till 14/8/2024. Although the petitioner has duly discharged her duty. According to Mr. Chauhan, the aforesaid anomaly has occurred due to failure of the BTC authorities to issue NOC pertaining to her posting. NOC of posting, is it?
NOC, my lord, to work there in the BTC.
Pertaining to discharge of her duty in the BTC area. Mr. S. Bora Lana SC BTC raised for posting this matter again after 10 days for motion so as to enable him to obtain preliminary instruction. Prayer allowed. List this case for motion again after 10 days. In the meantime, Mr. Bora to obtain preliminary instruction. 2 extra copies of the writ petition be furnished to Mr. S. Bora within 2 days from today. Mr. D. Learned Standing Council Health and Family Welfare Department is present on behalf of the respond numbers 1, 2, and 3.
Supplementary list for motion item 58.
In this case, my lord, I have given my lord caste certificate on the basis of my land documents, and it was also verified. But my dispute is, my lord, against the private respondent only, my lord. These are the two, my lord, union, my lord, Anupuchito Jati Jubo Chhatra Porikhod and Uttar Kasar Jila Jati Porikhod. Respondent number 5 and 6 are blood harassing me, my lord, in the name of again verification. But
What do you want? What relief do you want here?
I on the declaration that my certificate after verification they have given this. Kindly peruse your lordship. This letter
It
annexion 9.
cannot be done in a writ petition.
Yes.
How much time will you need? After that, I'll pass the order. You can't come and seek a declaration from the High Court that your caste certificate is valid.
And already verified also.
Maybe you
Yes,
can't
madam.
still. You go to the civil court. Otherwise, these matters have to be looked into by the committee, scrutiny committee, state level.
They've already verified. They paste annexion
Where
9.
is the cause of action?
Yes.
Huh?
They are harassing. I've had private
File a FIR.
Yes.
Somebody harasses you and the High Court will go on
After
declaring.
verification also, my lord. joint
Mr.
director-
H. Das, Learned Counsel for the petitioner, 6 posting of this matter again after 2 weeks for motion so as to enable him to obtain instruction as to whether this writ petition should be withdrawn for pursuing remedy in another forum. First of prayer allowed. Mr. C.K.S. Bora, Learned Government Advocate Assam, and Ms. J. Gogoi, Learned Counsel for the Social Social and Empowerment Department are present. You see, you examine this. This writ petition is not maintainable. You can't come and this is not a court of declaration and
Certificate issued, verified.
next time we'll dismiss it. Next date when it is listed, it will be dismissed. Your road will be closed. What are you all doing? Coming to the writ court for all these flimsy things? Somebody is harassing me, declare that I am a so-and-so, koi varto. Somebody is doing, is this the job of the High Court?
No.
I'll dismiss it with cost. 1 week, after 1 week. Yes. Just after 1 week, not 2 weeks. Yes, who is appearing in this case? All again after some time.
Order impeachment of party item 18.
That is, my lord, I have implead the private respondent and yes, my lord. To implead them for recast the seniority position. All of them are junior to me.
My lord, this petition has a fundamental flaw, my lords, because these are regularized employees, my lords, and there's a division bench judgment of 2018.
You will file objection.
My lord, we'll file. No, the implement we are not filing, my lord, but I'm just pointing out in the main petition, my lords.
Today will only.
Yes. Let them be implemented, my lords.
Mr. S. Chaudhary, Direct Counsel is present on behalf of the applicant. This IA has been filed with a prayer to implead the
The case of whom? 7 to 11. 7 to 11. Yes.
you want to implead whom?
They are all private respondents. 7 to 11. They are junior to me.
The
Up to so master by
officers junior to the writ petitioner as private respondent number 7 to 11 in the connected writ petition. I have perused the grounds stated in the IA. Mr. D. Gogoi, Learned Standing Counsel, Department of Public Health Engineering, has submitted that although he is not opposing the application for impleadment, the maintainability of the writ petition will be assigned at an appropriate stage. First up, be that as it may, for the present, this court is only concerned with the prayer for impleadment, having regard to the submission made at the bar and the statements made in the IA. The prayer stands alone. It is therefore, you see, your application, these applications are very wrong. It is not even in format. We will dismiss it. You have to make them opposite parties. You have not made them opposite parties, the persons you want to implead. You have just given their names in the body of the petition.
the IA, my lord.
What will you do?
Then my lord.
So you take down, cut everything. Mr. S. Chaudhary, Learned Counsel for the applicant, seeks leave of this court to withdraw this IA with liberty to file afresh after rectifying the defect. Mr. D. Gogoi, Learned so-and-so is present on. File an application. These are fundamental things.
Sorry.
For admission item 19.
I stand disposal of withdrawal with liberty to speak first.
In the case, I have filed additional affidavit for explaining the delay of filing this application. Actually, case.
Lords, we'll have to file an affidavit, my lords, because the additional affidavit has only been filed in August, my lords. The order is of 2018.
Mr. B.P. Sinha, Learned Counsel is present for the writ petitioner. Mr. B. Chaudhary, Learned Standing Counsel, LPDCL Authority, submits that a copy of the additional affidavit filed by the writ petitioner has been recently served upon him, and therefore he be granted 3 weeks' time to file a rejoinder. Prayer allowed. Let the matter be listed again after the ensuing puja vacation.
Or the affidavit in opposition, my lord. Affidavit in opposition, my lords.
Affidavit in opposition.
We'll have to file an affidavit in opposition, not a rejoinder.
Achha. Affidavit in opposition.
Deeply.
Item 21.
My lord, in this case, the government was to file affidavit.
One thing, my lord, this matter is no more res integra in view of the judgment of this honorable court in WPC 42 4274.
My lord, this
4274. And there's no need of filing any.
My lord, number of cases were filed initially, my lord, and the process of appointment was stayed by this honorable court. Later on, my lord, the stay was vacated and the government was allowed to, my lord, declare the result and to appoint the candidates, my lord. Now, my lord, my question in this case is, my lord, that results were declared on 6th March, my lord, and appointments were made on 5th March, my lord. How it can be, my lord? So that was the necessity, my lord, that the government has to clarify why the appointment can be made, my lord, without the declaration of the result. my lord.
Understand, no? ঠিক আছে।
Your lordship, as per our instruction, your lordship, on 5/3, your lordship, the 5th of March, your lordship, result was declared in the official website. On the same day, your lordship, after declaration on the website, appointment letters were uploaded in the official website, your lordship. The paper publication of the result was later on, your lordship. On the next day, your lordship, in the printed newspaper, your lordship, it was published.
You are appearing for whom?
For the state, your lordship.
You are appearing for whom?
Your lordship, the respondent number. Repetition. Sorry, your lordship. 1, 2, 3. Yes, your lordship. 1, 2, and 3, your lordship.
So where is your affidavit?
Your lordship, I am submitting only on my instruction, your lordship. Will file the affidavit, your lordship.
By when?
Your lordship, 10 days time may be given, your lordship.
You are
But
appearing for?
even though, my lord, I have already filed my affidavit, but so far this case is concerned, this the matter has already been decided by this honorable court in WPC number 4274/2018 on 27/8/2020, and the judgment has no judgment, and the operative part of the said judgment, my lord. May I read, my lord? However, after about 1 hour written examination was conducted without difficulty, it is also seen from the additional affidavit that consequent upon recall of the interim order dated such and such by subsequent order dated such and such in WPC number, say a total of 887 number of candidates were appointed on such and such, but the result of the candidates who had appeared in the aforesaid 18 numbers of examination centers were kept in abeyance subject to final report from the CID, Assam Police. The additional affidavit categorically mentions that the investigation by CID, Assam Police stood completed and a closure report by the FIR number such and such that they were submitted. As per the report, the complaints of anomaly did not stand substantiated and no evidence.
Mr. Bhatti, you read it at home. Because you're reading your own paper doesn't help the court in any way.
My lord, I'm going to supply to your lordship.
You read it in peace in your home. Don't take the trouble of reading now. We'll give them 2 weeks time to file affidavit and close the matter. Because he is not agreeing that it is covered by this judgment. So in any case, we have to pass an order. Heard Mr. J.C. Gold, counsel appearing for the writ petitioner. Also heard Mr. P. Sekar. Your additional AG, you're appearing as additional AG. Standing counsel of?
PNRD.
Standing counsel PNRD Assam, appearing for the respondent numbers 1, 2, and 3, who submits that within 2 weeks from today, an affidavit on behalf of the departmental authorities will be placed on record, indicating the manner in which the results were published in this case, thereby facilitating disposal of the writ petition. Mr. O.P. Bhatti, learned counsel representing the private
For respondent number 5.
Number 5.
My lord, one thing I submitted wrongly, my lord, I did not file any affidavit because the affidavit is not required to be.
The present case is covered by the judgment of this court rendered in the case of?
In
case number 4.
Why don't you give a copy? Give a copy. So and so, so and so. Mr. Gore has, however, contested the said submission. In view of the above, this court is of the opinion that counter affidavit on behalf of the official respondents will be necessary for disposal of the writ petition. As such, this matter stands adjourned for 3 weeks. On or before the next date fixed, the respondent numbers 1, 2, and 3 shall bring their stand on record by filing affidavit. This is the order, huh? This is the order. But after he records the particulars, give it back to them.
Here, my lordship, petitioner would have to file their affidavit, my lordship. They have not filed, my lordship.
Sorry?
Affidavit, my lordship. They have not filed, my lordship.
Lordship, we've sent the copy for vetting. I'm appearing on behalf of Mr. P. Nair.
Lordship, let the matter come up after vacation. In the meantime, we'll file our affidavit.
Exactly, my lordship, petitioner already in superannuation in the October 23, my lordship, we had not getting any relief, my lordship, that is why the matter is little bit urgent. So can it be before vacation? Because from a long time, they're taking time, my lordship.
All right. You are Miss B. Bhuya.
B. Bhuya, yes.
Miss B. Bhuya, learned counsel is present for the writ petitioner. Learned counsel appearing for the respondent numbers.
Respondent number 4, Lordship.
Respondent number 4 submits that affidavit has been prepared and has been sent for vetting. Therefore, 2 weeks time be granted for placing the same on record. Mr. R. Dhar, learned standing counsel PWD Assam, is present on behalf of respondent numbers 1, 2, and 3. What about your stand?
My lord, it's a BTC matter, my lord. Transfer subject.
Present on behalf of the respondent numbers 1, 2, and 3 and submits that the matter pertains to jurisdiction of the BTC authorities. First of in view of the request made by learned counsel for the respondent number 4, this writ petition is directed to be listed again on 4th of October 2024
Highly
as a
okay.
fixed item. In the meantime, affidavit on behalf of the respondent number 4 shall positively be brought on record.
Obliged.
Yeah, my lordship, can this matter maybe pass over about time being because are they already arguing this matter, my lordship? That is why, my lordship, he is court number 7, your lordship.
Only regarding quantum of the pension maintenance, my lord, family maintenance, my lord. He's the yearman, my lord. The maintenance was given, my lord, 13,800, my lord. And that is the spirit, my lord. As per DR calculation, it may be less, my lord. So, my lord, I will take definite instruction on 20 next week, my lord, next Friday, my lord.
Because the quantum of maintenance, according to my lord, that is will be 1/4, my lordship. That is will be decreased with the quantum of maintenance.
So, my lord, as for my lord, the hour, my lord,
You are appearing for whom?
I am for Union of India, my lord.
No. You are appearing for whom?
For
We are not asking for your identity. We are asking who are you representing?
yes, my lord. Airports, my lord, is for respondent, my lord.
Who are you appearing for?
Respondent 1, 2, 3.
Say that. That's the answer.
Yes, my lord.
We don't want to know
Yes,
whether you are a
yes, yes,
CGC.
there is no Union of India is a respondent 1, my lord.
Maybe, but I'm asking who are you representing?
Yes, my lord. Respondent 1, 2, 3, my lord.
And
I'm for respondent number 4. Thank you, Owen.
so let him obtain instruction.
Yes,
We'll put it on Friday.
because only disputed, my lord, is 13,800, my lord, this maintenance allowance, my lord.
Okay, Ms. B. Bhuya, learned counsel is present for the writ petitioner. Mr. S.K. Medhi, learned CGC, appearing for the respondent numbers 1, 2, and 3, submits that the core controversy involved in this writ petition pertains to the correct figure as regards the quantum of maintenance payable to the respondent number 4. Therefore, he be granted time till 20th of September 2024 to obtain specific instruction in writing, appraising the court of the stand of the department in the matter. Mr. K. Sharma, learned counsel, is present for the respondent number 4. In view of the prayer made by the learned CGC, this writ petition is directed to be listed again on 29/2024 as a fixed item, so as to enable him to obtain instruction.
Can it be before 27? Because this matter already pending before the lower court below. That is why. 25th.
22.
Obliged, your lordship.
May I please, Lordship? So in this matter, the affidavit of the deputy missionary is required, Lordship. And on the last occasion, if your Lordship, there is the last order, they have taken time in this regard to file the affidavit.
Yes.
May I have give some time, Lordship, to file my instruction?
How much time?
Lordship, 2 weeks, Lordship.
Affidavit is required, Lordship.
The petitioner's counsel is present, Mr. J. Goswami, J.K. Goswami, learned additional senior government advocate. Assam prays for further 2 weeks time so as to enable him to file counter affidavit on behalf of the official respondents. The prayer is not opposed by the petitioner's counsel. Mr.
L. Sangam.
L. Sangam.
May I,
In view of
may I
the
please
above,
pray for it, Lordship?
let this matter be listed again on 25th of October 2000.
Much.
The petitioner was imposed a penalty. Against that, he has preferred appeal. Appeal is pending. And affidavit,
What is the penalty?
recovery of 57 lakhs.
57 lakhs.
50, so around that
57.80 lakh. Now, Lordship, the penalty was for imposition for a direction to deposit that amount. To deposit the amount of 57.8 lakhs. We had contended that under Rule 21, there cannot be a direction for depositing that amount. They have the right to withhold the amount from our pension. And as regards the
Why this amount was sought to be recovered?
Lordship,
there was a
Lordship, there were a DP against me, wherein I was found guilty. Against that, Lordship, I had preferred an appeal. That appeal we. Lordship,
Why the recovery of DP? Guilty means increment. Stoppage of.
Lordship, we had retired in the meantime. On 31/5/21.
Right. You are not answering the question. Then I heard Mr. Chakraborty and counsel.
Lordship, there was an allegation that an amount of 57.8 lakhs was stolen while I was serving as the DFO.
Stolen.
Stolen from the custody of the DFO's office. And in that, a departmental proceeding was initiated against me for that purpose. And in that, it was found that
It was stolen in cash.
In cash.
Why so much money is kept in cash?
Lordship, at that point of time, Lordship, the rules were that the bank accounts, current accounts, a direction was given to close the current accounts by the governments. So as the direction was there to close the current accounts, the amount had to be withdrawn from the current account and kept in the trunk of the office, Lordship. And during the intervening night of Bihu, Lordship, the amount got stolen. And in the departmental proceedings, the authorities came to a finding that I was.
What has happened to the appeal?
Lordship, appeal is pending till this.
Why pending since when?
Pending since 14/9/2022. 2 years have passed by, Lordship.
Status of appeal has been, we have asked them to provide, they have not provided. My Lordship will fix this, after a week, I can get an updated status. If the appeal is going on, Lordship can close this matter. If there is any session of the appeal, because if appeal is successful there, this writ petition is, it becomes.
But your authority is not.
I'll ensure, my Lord, just a week, Lordship will give me.
After a week,
State counsel for the petitioner also heard Mr. D. Gogoi, Learned Standing Counsel, Foreign Department, Assam, who seeks posting of this matter again after 10 days for the limited purpose of obtaining instruction and appraising this court as to the status of the appeal referred by the writ petitioner. Mr. D. Bhattacharjee, Learned Standing Counsel.
Respondent for AG.
Appearing for the respondent number 4, Accountant General Assam is present.
May I pray for a date after 10?
List the matter again after 10 days as a fixed item.
Oblige.
Page 18 may kindly be seen. The petitioner was appointed as work charge work charge section assistant. And persons who were appointed with him, all other persons have been regularized. In the year 2005, 2006, that your lordship will get it at page 20. Her case has not been considered till date, my lord. In similar circumstances, your lordship, in case of regularization, I got a Supreme Court order which says, my lord, that she should be treated same like that of the persons who are regularized.
Yes, who is appealing?
May I place the judgment? Apex total.
My lord, regularization part, my finance, at the end of the day, my lord, finance has to give concurrence for regularization.
So what are we supposed to do? Are we expecting us to go to the finance department?
No,
Then
no, my lord.
What kind of submission is this? Regularization, finance, so and so, economics. How are we bothered about it? You are representing the state. Tell us what is your stand. We are not interested. Who is looking
My
up?
lord, our stand is, my lord,
Hmm.
my lord, after Upendas, my lord, we cannot, my lord, regularize, my lord, after Upendas.
Why?
The three conditions of, my lord, para 52 of Umadas, that has to be, my lord, fulfilled, my lord.
Right.
That part has to be seen, my lord, first whether this.
Why it is not fulfilled here?
It was not in sanction post, my lord.
Have you stated it in your affidavit?
No, we haven't filed that affidavit, my lord.
Why?
That is there, my lord. We,
1990 they were appointed.
we'll file, my lord, affidavit in short time, my lord.
You are appearing in this case. What is your stand? Be clear about it. Don't make this argument before the court. This is finance, this is PWD, these are all state agencies.
I'm sorry, my lord.
My clear stand is that after Umadevi lordship, three conditions are there. Only those persons who fulfill those conditions, their cases can be considered for regularization, otherwise not.
Then in Upendas also, you have to pay a particular minimum of pay scale.
That is there.
Have you given it to her?
Most probably he's getting that.
Huh?
Should get.
What do you have to say, Mr. Das?
My lord, the regularization order, your lordship will kindly see page 20. In pursuance of the Undersecretary to the Government of Assam PWD letter dated the following WC, tracer and section assistant are brought under the regular scheme. So the persons who were appointed along with me, my lord, in the year 1990, they have been given regular scale of pay. Petitioner has not been done. That is what my Supreme Court judgment which I have placed, my lord. Persons who were regularized, my lord, similarly situated persons regularized, benefit was not given to the petitioners. Apex Court said, no, you treat her and same like the.
So
like
what
that
is your answer to this? If others could be regularized, why not pay? You can't take Umadevi's plea.
1990 they were appointed.
My
And
lord,
they have regularized all the persons.
on
who
what
was-
basis this PHU department, they have regularized, my lord, that PH is not a party here, my lord. I am from PWD, my lord. That's a different department.
Who is appearing for the NCLs? You have to explain.
Initially joined in June, then he was transferred Karimganj. So they are supposed to send the file for regularization.
You have nothing to do. All right, all of you file your separate affidavits.
Mine.
And if you, on the next date, if the affidavit is not there, then we'll find another way of doing it. Mr. B.D. Das Lana, Senior Counsel appearing for the writ petitioner, has relied upon a decision of the Supreme Court rendered in the case of Ushaben Joshi versus Union of India and others, third bracket, SLP civil, bracket civil, third bracket, SLP, then small, first bracket civil, bracket close, number 6427 of 2019, third bracket close, to submit that since the persons who were originally recruited along with the writ petitioner have been regularized way back in the year 2006, the authorities could not have extended a differential treatment to the writ petitioner so as to deny him the right of regularization. First of all, the learned Standing Counsel PWD Mr. R. Dhar, the Standing Counsel Finance Department Mr. P. Nayak, Finance Department Assam P. Nayak, and Mr. C. Sharma, Learned Standing Counsel Dimahasau Division, does not have any specific instruction so as to respond to the above submission of the petitioner's counsel. First up, it appears that unless an affidavit is filed by the respective departments bringing their stand on record, it will not be possible to adjudicate the plea raised in the requisition. As such, on the request of learned counsel for the respondents, this matter is adjourned for 4 weeks. It is made clear that within 4 weeks from today, the respective departments shall bring their stand on record by filing counter affidavit.
My lord, only one prayer, my lord. In page 23, my lord, Annexure 5. It seems they have filed a representation before the authority, my lord.
Bring your stamp.
There will be no bar, my lord, to dispose of this.
They will dispose of negatively, always.
My lord, he has filed it, my lord. That is what, my lord, I was answering.
May it please your lordship, here in this matter. Lordship, the matter may be adjourned for the day.
Adjourned for 1 year.
No, adjourned for the day, lordship.
For the day only.
Lordship, my senior is not well. Lordship. Senior is not well. Lordship, in the
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks. Mr. D. Upamanu, learned standing counsel, Health Department, Assam, is present on behalf of the respondents.
have your blessings.
Item 28.
Please, your lordship, on the last occasion, Honorable Court seeks for the instruction relating to reinstatement, lordship. An instruction has come, lordship. May I produce the instruction? A minute.
So they are processing your reinstatement. How
I
long
have
will it take?
not seen the order manually. They have not supplied me copy. I have not seen it.
How long will it take?
Lordship, 2 weeks.
On Monday, you give us the order of reinstatement. Reinstatement cannot take such a long time.
Lordship, in that case, 1 week time, lordship only.
Take down. Mr. D. Varalani, counsel for the petitioner, is present. In terms of the order dated 9/9/2024, passed by this court, Ms. M. Kotoki, learned standing counsel, Animal Husbandry and Veterinary Department, Assam, has produced a copy of the written instruction obtained by letter dated 12/9/2024, issued by the Joint Secretary to the Government of Assam, Animal Husbandry and Veterinary Department, a perusal of which goes to show that the department is processing the file for reinstatement of the petitioner without prejudice to the pending departmental proceedings. Departmental proceeding inquiry report
Inquiry first,
Madam,
inquiry
earlier
has already
outcome
submitted, lordship. No,
of the
pending.
proceeding pending against him.
Against.
First of, Ms. Kotoki submits that within a week from today, the order of reinstatement will be issued. First of, taking note of such submission of the Learned Department Council, this matter is directed to be listed again on 23rd of September 2024, so as to enable her to produce a copy of the order of reinstatement. Next date, we are calling the officer. If the order
Earlier, they have stated the petitioner is going to be exonerated from the.
So it's not exonerated, lordship. We are saying
There is
that
a
we are
order
going to
recorded.
reinstate, lordship, as further ICC, before the ICC is also pending.
That's a bit fix it on
23rd.
20, at least.
My lord, here to selection to the post of administrative officer in the district commissioner office, Bajali, is under challenge. My lord, the respondent number 4 has filed an affidavit I need some time to file a rejoinder to that now. Government has also filed an affidavit.
In this case, my lord, GID is to file a affidavit to clarify the whole thing
You are appearing for whom?
for a private respondent, respondent number 4.
And therefore, as for number 3, deputy commissioner also, we have also filed that.
You filed
But
affidavit.
respondent number 1, commissioner and secretary,
Heard Mr. P. K.
GID.
Learned counsel appearing for the writ petitioner. Also heard Mr. C.K.S. Burra, learned government advocate Assam, who submits that affidavit on behalf of the respondent number 3 has already filed. Mr. R. Muslim,
for
learned
one.
counsel appearing for the respondent number 4 has also made a submission that counter affidavit on behalf of his client has already been brought on record. Mr. Roy Chaudhary prays for 2 weeks' time to obtain instruction and file rejoinder affidavit. Prayer allowed. This matter is directed to be listed again after 3 weeks, along with the rejoinder affidavit, if any, filed by the writ petitioner.
My lord, what I was submitting GID, respondent number 1. His affidavit is very essential, or the.
You are
the
the petitioner or the respondent.
I am
Then
private
the petitioner will submit if the affidavit is required, not you. You are to only answer his queries.
Because.
All right, next matter, please.
Item 30.
Yeah, please, your lordship. Not in this case, no affidavit has been filed, my lord.
Lordship, this will be as Lordship has passed order in item 5, Lordship, same.
Item 5.
This is of 2013, Lordship.
And Mr.
F.L. Oscar.
And counsel for the petitioner also had Miss and
Appearing for 2 and 4, Lordship.
Carry for respondent numbers 2 and 4. Miss A. Nyog. DS Nyog has appeared for respondent numbers
1 and 3.
1 and 3. This matter pertains to. So this is what you want to file affidavit.
Lordship, there is no point in filing affidavit, Lordship. We already have stated that the LC has not considered this, Lordship. And what they are telling this 6/1/2015 WEM to be applied in their case. So as per the judgments of this Honorable Court and also of the Honorable Supreme Court, Lordship, the
On the
WEM
prayer of learned counsel for the petitioner, let this matter be listed again after the puja vacation.
obliged, your Lordship.
Item 32.
Matter relating to realization of pensionary benefit. And in the year 2022, she resigned from service, but that benefit is not given. As per the last order, instruction is to be obtained.
Lordship, I am seeking another 4 weeks' time, and here what they are telling, Lordship, not there. So the petitioner herself corrected the service book, and she her retirement was 2 years before, Lordship, and that's why she has put the resignation, Lordship. So everything is little time is required, Lordship, to get this.
So let them give the reply.
All right. Mr. M. Das
We can appear for users again.
is present for the writ petitioner on the request of Ms. M. Bhattacharya and government additional senior government advocate Hassan appearing to the official respondents. This matter stands adjourned for further 4 weeks so as to enable her to obtain instruction file affidavit.
Yes, your Lordship.
Item 33, 34, and 35.
Well, in item number 33, I have received the instructions. My affidavit is ready, but by Monday I'll file. Kindly, I pray for taking up the matter on Friday. There is an interim order going on and the appointment process has been stayed. Some urgency is there on our part. Kindly take it up on Friday next. By Monday we'll file.
Not Friday, Monday, following
Monday.
Along the next Friday would be, I think, will be 2-0. Let it be taken up on 23rd.
Sorry. But Mr. K. M. Chaudhary, learned senior counsel appearing for the petitioners in item 33 and 34. Also have Mr. L. Majumdar, learned counsel for the petitioner in item 35. Mr. D. Nath, learned senior government advocate Assam, appearing for the
35 we are connected names.
state of Assam. In these writ petitions submits that
In 34, we have already filed. In 33, we'll file.
35 is perhaps another case wrongly tagged.
35 is wrongly tagged.
Acha, then 33 and 34 submits that L.R. Majumdar Patna submits that counter affidavit on behalf of the state has already been filed in item 34, and insofar as item 33 is concerned, he has received instruction and filed affidavit
By Monday, we'll file.
by
Affidavit is
16/9/2024. As such, Mr. Nath has prayed for posting these matters again on 23/9/2023 as a fixed item by extending the interim order till then. First of Mr. K. N. Chaudhary, learned senior counsel, has no objection to the said prayer. In view of the above, let both these writ petitions be listed again as fixed items on 23/9/2024. In the meantime, the department to file counter affidavit in item 33 as projected by Mr. Nath. Interim order passed earlier to continue till the next date. Item 35 is separate.
35 is separate.
You write, Mr. L.R. Majumdar, learned counsel for the petitioner. submits that
It is a covered case, Lordship may dispose of Sanjita Roy versus State of Assam.
It's a covered case, Your Lordship. So
Covered.
submits that the issue raised in this writ petition is covered by the decision of this court rendered in the case of Sangeeta Rai and others versus State of Assam reported in so and so, and therefore the matter be reported in 2019 bracket 2 bracket close GLT 805, and the matter be disposed of accordingly. Full stop. The facts of the case in a nutshell is that the writ petitioner herein was initially engaged as a master roll worker, whereafter he had joined on 1/1/1993. First up. During the course of his service, the petitioner was regularized and thereafter he regularized as Khalasi, and thereafter he retired from service with effect from 22/7. Regularized as Khalasi with effect from 22/7/2005. First up. On attaining the age of superannuation, the petitioner retired from service with effect from 31/10/2017. First up. The grievance of the petitioner is that although he is entitled to receive pension under the rules, his prayer for payment of pension has been rejected by the authorities. Hence this writ petition. First up. Mr. R.R. Gogoi, learned standing counsel. This is for PHE department. Where is the judgment of Sangeeta Roy?
Lordship, it is page Lordship
5, page
5,
17.
17.
Appearing for the PHE department has submitted in its usual fairness that there is no dispute about the fact that the petitioner has rendered more than 20 years of regular service as Khalasi, and therefore, in view of the decision of this court in the case of Sangeeta Roy and others, bracket Supra, he would be entitled to pension. First of all, taking note of the decision of this court in the case of Sangeeta Roy Supra and the submission made by Mr. R.R. Gogoi as well as Mr. R.K. Talukdar, learned standing counsel appearing for the AG Assam, both of whom have agreed that this is a covered case by the decision of Sangeeta Roy Supra. This writ petition stands disposed of with a direction that the respondents will now process the claim of the petitioner for payment of pension as per the decision of this court in the case of Sangeeta Roy and others Supra. within a period of 3 months from the date of receipt of a certified copy of this order.
Obliged.
Lordship,
Petition stands
if terminal gratuity receive, if any, that may be adjusted in the pension.
It is however made clear that the terminal benefits, if any, already received by the petitioner shall be adjusted against his retirement stroke pensionary dues.
For orders, I don't.
It petition stands disposed of accordingly.
Lordship, in
What
terms of last,
IA?
no. Lordship,
What was your prayer in the morning? You made a request in the morning.
Lordship,
What is the request?
I filed an IA yesterday, Lordship. That was
IA is for what?
IA for implement of a party, Lordship.
Then it has to be listed. You can't get IA by a statement. Mr. D. Dole, Learned Counsel for the petition submits that yesterday an interlocutory application for implement has been filed on behalf of the petitioner, but the same is not on record. As such, Mr. Dole prays for posting this matter again in the next week along with the IA. Mr. S. Dattal and Senior Counsel listed by
S. Musahari, my
Ms. S. Musahari as well as Ms. R. Devi, Learned CGC and Ms. S. De are present on behalf of the respective respondents and do not have any objection if the prayer is allowed.
Item 41.
May I please, Lord?
Yes.
So this I is for restoration of writ petition number 7411, Lordship. So on the last occasion, on the 16/8/2024, Lordship, the matter was called for. But on that day, the day was Friday, and I went to Zuma prayer, Lordship. I went to Zuma prayer, Lordship.
Yes.
And when the matter was called for non-appearance.
So what can be done? The court proceedings will go on. You go wherever you want.
Lordship.
But you want the judge to follow you. Then
Lordship, when the matter was called for, it was.
Sorry.
Lordship,
we'll have to issue notice in this case. Not Mr.
Ahmed Soikia. Ahmed Soikia.
Ahmed Soikia and counsel for the petition. This IA has been filed with a prayer to. See, these are not grounds. You may go anywhere here, there. That's we are not concerned.
Lordship.
But the court proceedings dismissed, then you file an application again. The judge is this can't go on. Then you should have asked for adjournment in the morning.
No.
You should have asked for adjournment.
No.
This IA has been filed with a prayer to reinstate the writ petition by setting aside the order of dismissal for non-prosecution. Issue notice returnable in 4 weeks. Copy of this IA be served upon the Learned Standing Council PWD so as to enable him to obtain inspection. Anybody for PWD here? Okay. Then you accept notice. Mr. B. Gogoi, Learned SC PWD accepts notice on behalf of the respondents.
Yes.
As such, no formal notice is required to be sent in. Let this IA be listed again after 2 weeks. Issue notice within 2 weeks.
Item 42.
May I please, your Lordship? There is a delay of. I have filed one MC case for restoration of WBC, which was.
What is the IA number?
IA 739. There is a delay of 2936 days. I have filed one restoration petition. The WBC was dismissed earlier.
2,929 days.
Yes, I may be allowed to file objection, madam.
We'll dismiss it, but not today. Why 3,000 days delay?
Yes, my lord.
That means you are not serious about this.
He came to know on 8/11/2023.
A time has come when these things will have to be treated very strictly. Can't go on like this. He has missed the bus. You want the order to be passed today or on the next date? Order of dismissal.
As per courts.
Today also you don't mind? We'll discuss it today, yes. Heard Mr.
Eke Hanan.
A.K.
Hanan.
Anand, counsel for the applicant. Ms. A. Gayan and CGC is present on behalf of the opposite parties. This IA has been filed under Section 5 of the Limitations Act 1963 with a prayer to condone the delay of 2929 days in preferring the connected application for restoration of WPC number 2826/2007, which was dismissed for default by the order dated 23/1/2014, passed by this court. What is the writ petition about?
He was terminated from his service.
They didn't serve the writ petition, my lord. They only filed the IA, my lord. What's the writ petition? Petition to answer.
Yes.
It appears that by filing the writ petition, the petitioner has challenged the order of dismissal from service dated 18/6 issued on 18/6/2006, terminating the service of the petitioner as
BSF constable.
As BSF constable. More than 18 years have lapsed since the termination of service of the petitioner. Be that as it may, after going through the statements made in the IA, we find that there is no satisfactory application. This court finds that there is no satisfactory application for the delay of explaining the delay of 2929 days in preferring the connected restoration petition. The learned counsel for the applicant also could not convince this court by urging relevant grounds as to why the IA should be allowed by this court. In view of the above, this court is of the opinion that there is no valid ground for this court to condone the delay of 2929 days. This IA is accordingly dismissed. Consequently, IA is accordingly dismissed. What is this miscase 20 of 2024?
Restoration of the.
Consequently, MC number 20 of 2024 shall also stand disposed of.
Obliged.
Well, here the compliance is there, my lord.
None appears for the
In last occasion also nobody appeared.
petitioner. Give me the contempt case file. The petitioner in the contempt case, when the matter was called up before this court today, Mr. B. Gogoi, learned counsel, appearing for the
My lord, the respondent numbers, my lord. All the respondent numbers.
appearing for the
Respondent 3, my lord. I have filed the affidavit.
submits that the order of this court dated 28/9/2018
Yes, ma'am.
has been duly complied with.
In fact, what has happened is, my lord, the direction was that, my lord, if not placed before the SLC, it should be placed. But prior to the order, it was placed on 19/6/2018.
Inasmuch as the case of the petitioner was duly placed before the SLC.
And a speaking order was passed on 22/11/2018, rejecting the.
And a speaking order was passed on 22/11/2018. 2018.
My lord, rejecting the claim for
So
completion.
it was placed in 19 and passed in 2018. What are you saying?
No. Consideration on 19/6/2018.
Achha. Placed before the SLC on 19/6/2018 and a speaking order dated
22/11/2018.
22/11/2018 was passed by the SLC rejecting his claim. Full stop. If that be so, nothing further survives for adjudication. Survives in this contempt case. The same is accordingly closed. Consequently, IAC number 841 of 2024 shall stand disposed of.
Obliged.
May the contempt petitioner has died.
Hmm.
So we have filed this application IF for 885 of 2024
Hmm.
for substitution of the legal heirs of the petitioner.
What is the direction?
Direction, my lord.
Payment of leave and
Leave
encashment and
encashment and gratuity, my lord. Page 9 of the contempt petition.
So we'll allow it. We'll allow it.
Yes, Lord.
Yes. Mr. A. Bhattacharya, learned counsel for the applicant, submits that during the pendency of the contempt case, the contempt petitioner has died, leaving behind his legal heirs. Therefore, this IA has been filed to substitute the deceased petitioner with his legal heirs as petitioner numbers 1 bracket Roman 1 to 1 bracket Roman 6.
7.
Roman 7. That is the present applicants. Full stop. Mr. R. Sharma, learned counsel, is present on behalf of the sole respondent and does not have any objection if the prayer is allowed. In view of the above and considering the statements made in the IA, the prayer for substitution stands allowed. The applicants shall stand substituted in the connected contempt case in place of the original petitioner. The applicants to file amended cost title within 10 days from today. Register to list the contempt case thereafter for necessary orders. IA stands disposal.
Obliged.
Obliged.
Maybe contempt petition lordship. Lordship will see the lordship's order dated 26/7/23. Lordship will see the last two paragraphs lordship of your lordship's order.
What is the IA for?
I am lordship to impeach the present incumbent lordship.
Lordship, some fresh instructions are forthcoming. In 2 weeks, Lordship will update this court on the matter.
Last 1 year lordship, there are just 2 weeks plus for instruction.
What a contempt case 5 years has
Yes,
gone.
lordship.
What instruction?
And one after another, there is passing lordship speaking order despite order of this noble court.
Which order has not been complied? What is the date of the order?
It was lordship.
What is the date of the
Lordship.
order?
Page number starting of page 17. It is order dated lordship 18/12/2018. Lordship has already observed the order. Lordship owns order is at page lordship order dated 26/7/23.
Sorry?
26/7/23. This honorable court has passed an order in this contempt petition. Lordship.
Mr. Bhotakar, where is the order which has
Yes,
not been?
page 17 lordship.
Why are you talking about 26/7? It is 18/12/2018.
18/12/2018.
So there is a direction to consider the petitioner's case for appointment to a grade 3 post. It took 6 years. It is taking more than 6 years to comply with the direction.
The only catch was that Lordship, when the petitioner had applied for compassionate appointment, Lordship, he only had qualifications for grade 4.
That's all right. Consider if it is not entitled, then you say so.
We'll advise the department to Lordship resolve this issue as soon as possible.
25th. And if the order is not complied with by 25th, your officers are coming on 27th. Tell them.
Earlier, lordship has already directed them to personally appear.
Heard Mr. J. Kalita Lana, counsel for the petitioner stroke applicant. Also heard Mr. Bothakur. What Bothakur you write?
I brought up
I Bothakur, Lana, counsel appearing for the
respondents.
respondents who seeks posting of these matters again on 23/9/2000, 25/9/2024, so as to give him one final opportunity to seek instruction and appraise this court as to what steps have been taken for compliance of the court's order passed way back in the year 2018. Prayer allowed as last chance, list the matter accordingly.
Item 46, 47, 48, and 59.
In item number 46, you have filed an application.
46 and 47, 48 and 14 are different matters.
These are the, no. 46, I'm asking, 46, in the item of 46, I have filed the IO.
In 46, that IA has been filed to Mr. TC Sutia lawsuit, not to us lawsuit. That's why they have not filed the IA to the standing counsel legal lawsuits. That particular IA they have filed in this item number 46. I have checked the file. I have seen that it was submitted to Mr. TC Sutia, additional senior government advocate.
Is it so, Mr.
No, thereafter we have served another money, this money.
And Lordship may kindly peruse the order. Anyway, Lordship may kindly peruse order 6/1/2023. There was a direction by its honorable court to the secretary, commissioner, secretary, personal aid to cause an inquiry. 6/1/2023 order may Lordship may kindly peruse.
No, just a minute. Are you appearing in all these cases?
Yes, Lordship, for Agriculture Department, Lordship, item 46. 47.
And what about 40?
Only 46, our name is shown. Only in 46, Lordship.
What about 48 and 49? What are these cases?
This item relating to the issuance of a notice issued by the department terminating our service. That's why you have filed this writ petitions, and that stay order was granted by this honorable court. But this item number 46, that is relating to the payment of the salary from the month of January 2017 to till date. In the meantime, they have paid my salary up to the March 2017. Thereafter, they did not pay. They have also filed an affidavit in opposition. Your Lordship may kindly come to their this affidavit in opposition at page number 24, where they have admitted that the salary is paid up to March 2017. Thereafter, no salary is paid. Now you are demanding now you are demanding, my lord, if this salary from the month of April 2017 to August 2018 is paid to us, we shall leave the job. We are not interested. We have also filed a petition before the Department of Agriculture. They have considered. Thereafter, they have submitted a report. It's a report was submitted by the committee. If their salary is paid, they are ready to leave the job, and that was on the record. That's why we have filed this application, that they have not considered and not paid our salary. If we are all our senior citizens, my lord, having the age of more than 74, 75, 76 like this, my lord, and we are not interested in continuing with the service. In fact, my lord, before starting the COVID period, we have left the service. So we are demanding only 16 months salary. If that is paid to us, my lord, we shall leave and withdraw all these our cases, my lord.
16 months salary from which period?
From month of April 2017, my lord, to August 2018.
So all the applicants, petitioners are.
Yes. All are ready, my lord.
And we have, this is an item number?
46, my lord. Item number 46.
And what about 47, 48 and 49?
That is relating to the stay order granted by this honorable court not to terminate our service. So if this prayer is allowed, your lord, we shall withdraw remaining cases.
Order dated 6/1/2023.
No, just a minute. What do you have to say on this prayer?
No, they are not working after March 2017. That's why they have not been paid. Lordship. There's a categorical statement, and for that, Lordship, Lordship may kindly pay order dated 6/1/2023.
Passed in
passed in in the series of WPC number lawsuits 413 of 2017. এইটো হ'ব আপোনাৰ 47 46 তো আছে 46 আছে 46 তো আছে it is in the 40 item 46 also lawsuit 6/1/2023
Yes.
and lawsuits para 4 lawsuit may kindly 3. The authorities in the Agriculture Department of Government of Assam, on the other hand, take a stand that petitioners after March 2017 are not working, and therefore the salary had not been paid up to March paid, and up to March 17 they had been paid as required. The petition is instituted claiming salary for a period after March 17. Para 4, it should have been 5 lawsuits. In view of the disputed claims made by the rival parties, we require the commissioners and secretary to the Government of Assam in Personnel A Department to cause an inquiry, giving an opportunity to the petitioners to produce relevant materials that they may desire to produce to substantiate that they are working even after March 2017, and also giving equal opportunity to the authorities in the Agriculture Department to produce any material documents that they may like to produce to substantiate that petitioners are not working after March 2017, and thereupon pass a reason order on the factual determination as to whether petitioners are working beyond March 2017 or not. So there is a direction from the Honorable Court. And Mr. Ardhar, my friend, he was directed lawsuits, but he.
My lord, I will say, my lord, this personal department is not a party, and my name is not shown. I have just come to know about this case now only, my lord. It's a way back. I have sent it. I remember it, my lord, way back in 23. So I have to again now ascertain what decisions or
Because Personnel Department is a neutral party, that's why Commissioner Secretary Personnel Department was directed to make an inquiry.
So what is the outcome, my lord? I don't know, my lord.
My lord, may come.
Let him inform the court. What is
That was the direction, but they have not followed the direction. They did not submit any report as per the direction given by this honorable court. But in their affidavit, my lord, at page 22, they have submitted affidavit. In the affidavit, they have admitted that you are still continuing the service, my lord. That affidavit was filed in the month of March 2018, my lord. I am reading some portion of this affidavit. Number 2, paragraph 10, that the deponent begs to state that after March 2017, the petitioner have not received their salary till now. However, the process is on the release the salary for ATM details by the authority. It is to be mentioned that in addition to the salary, the petitioner received monthly pension, this and that. Thereafter, my lord, they have also made a statement, my lord, that the petitioner still attending office and salary of the petitioner may be made subject to availability of the fund. They have admitted that we are still attending. That affidavit was given by the respondent number 2 and 3 on 16th day of March 2018.
All right. Heard Mr. R.C. Sancheti, learned counsel for the applicant read petitioners appearing in this batch of read petition. Also heard Mr. S.M.T. Chestry, learned standing counsel for the Agriculture Department, Assam, appearing for the official respondents. Who has invited the attention of this court to the order dated 6/1/2023, passed in this batch of read petitions, to submit that until and unless an inquiry report is made available in terms of the aforesaid order of this court, no further order would be maintainable on the prayer of the read petitioners stroke applicants for payment of salary for the period from April 2017 to August 2018. First up, on 6/1/2023, this court had passed the following order. It court cut paste Mr. R. Dhol, learned standing counsel, Personnel Department, Assam, submits that since his known additional senior government advocate, Assam, is that since his name is not shown in the cause list, hence he is not prepared with any instruction in the matter today. Mr. Dhar, however, seeks 2 weeks' time to seek instruction as to what action has been taken by the departmental commissioner in terms of the order dated 6/1/2023 passed by this court. On the request of Mr. Dhar, this matter stands adjourned for 2 weeks so as to enable him to obtain requisite instruction and appraise this court register to list this matter again by reflecting the name of Mr. R. Dhar, learned additional senior government advocate Assam in the cause listing.
My lord, a date may be fixed. My
Huh?
lord. A date may be fixed. My lord.
It will
Come after vacation. All are the senior citizen, my lord. All are senior citizens.
But they are not working.
Their
Lordship.
position-
But they are not working.
It is fact. We are not working, my lord.
First October.
First, not first
Obliged.
October.
Item 50 and 51.
May I please, your Lordship?
Yes. What you wanted in the morning?
Lordship, I have filed an affidavit, Lordship. As per direction of this honorable court, I have submitted representation on 19/8/2024, Lordship. What I responded on that, Lordship. As per last order.
Let's see the contempt case. Why two IA, miscase and IA?
Lordship, one for implement, Lordship, new incoming, implement of new incoming, and one for Lordship.
In the morning, you made a mention.
Yes, Lordship. I have
What
filed
was?
affidavit, Lordship. As per direction of this honorable court, on 7/8/2024, Lordship. As per
You filed affidavit.
Yes, Lordship.
But it is not on record.
Yes, Lordship.
Acha. Mr. Your name, please?
Gigi Gogoi.
Gigi Gogoi, learned counsel for the applicant, submits that in terms of the order dated 7/8/2024 passed by this court in the present proceeding, an affidavit has been filed
Today.
on behalf of his client this morning. First up, however, the said affidavit is not on record. In view of the above, register to take the affidavit with the record of this case and list the matter again for necessary orders.
Item 52.
Lord, the matter relates to supersession of the petitioner in the grade of the general manager of the insurance companies. Now, in 2023, there was a selection, the petitioner was superseded, and in 2024 also he was superseded. Now, my lord, while moving this petition, an interim order was passed. The lordship should kindly have a look at the order. 24th of May 2024, an interim protection was given, my lord.
The IA has come up for
Yes,
orders.
yes.
What is
I'm
the IA?
coming to- Well, IA actually we are seeking a direction because in the meantime one vacancy has arisen. So my lord, what ideally I would like, my lord,
Yes.
the insurance company should file the affidavit immediately, lordship should hear the matter. And the interim order passed in the main writ petition should be passed in the IMB, so that they do not fill up this post. There is already an order considering the submission made by the learned counsel for the petitioner that there are vacancies. It is provided that one post of general manager shall be kept vacant if there exists any vacancy. Now, what has happened? Respondent number 8, who was the chairman come managing director, no? She has been transferred to another company. Therefore, naturally, one vacancy has arisen. It will have a consequential
There
vacancy.
is already an interim order.
No, what I'm, yes, my lord. So what I want is, my lord, no, my lord, at that point of time, we were relying on 2 deputation vacancy indicated in the petition. Now a clear vacancy has arisen. So all that we are saying is interim orders should be made extended. So to cover the IA, prayer in the IA, and let them file their counter, my lord, lordship will fix a date after the vacation, lordship should hear this matter.
Let's may I submit? Because I appear for all the insurance companies, respond numbers 2 to 8. First, the understanding of the petitioner with regards to arising of a vacancy is incorrect, my lords. A CMD level officer has been transferred from respondent number 8 to respondent number 2. This is not a class, this is not a scale 7 officer, which is the promoted cadre for which the writ petition has been filed seeking a relief in that cadre. So that's number 1, my lords. CMD transfers are taken care of at the cabinet level. There's an appointment committee at the cabinet level which makes those transfers. There has been no promotion from a scale 7 to a CMD. If in case that had happened, a scale 7 position would have become vacant, but that has not happened as on date, my lords. That's number 1, my lords.
And secondly, we are bound by the orders which have already been passed by this honorable court on 24th May. My lords, the order is very clear. In case a vacancy arises, we have to keep it vacant, and we will keep it vacant. There is, we can't run away from the court's order. So therefore, in my respectful submission, this IA is nothing but just a re-agitation of what was argued during the motion hearing, my lords. So nothing.
Have you filed counter affidavit in the writ petition?
In the writ petition, I was granted 4 weeks to file my counter affidavit as per the last order, which was passed on 30th August, my lords. Those 4 weeks have not expired yet.
20th of August, it's mentioned May.
My lords,
24th of May, it's mentioned.
my lords may have 30th August order, my lords. 24th May was the motion hearing. I was not there. I was not before the court at that
The
time. my lords.
notice was issued for 4 weeks.
That's correct, my lords. My lords may have 30th August order, please. Just for a moment, my lords. That's the last hearing in this matter, my lords. 30th August, last but third paragraph, my lords. On the prayer of the learned counsel R2 to 8, consideration of the matter is deferred by 4 weeks to enable filing of counter affidavit. And for the IA, the next paragraph, since urgency has been expressed, objection be filed within 2 weeks. This I've already filed. IA is listed today. My 4 weeks that were granted to me on the last date of hearing are yet to expire. I will file my counter within
So
that.
you file a counter, by when will you file counter?
Within the 4 weeks that have been granted to me, my lords. I will not exceed that time.
We'll fix a date in the month of
Yes,
November.
absolutely.
After
Absolutely.
the, Lordship will keep the IA alive. They have filed an affidavit, we will file a rejoinder to that regarding our understanding.
Yes. Mr. K.N. Chaudhary, and
No,
his
say,
senior counsel,
okay,
the
killing
petitioner. Mr.
Zorawar
Zorawar
Singh,
Singh,
please,
learned counsel, has
If there is
appeared on behalf of the respondent numbers 2 to 8 and sought 4 weeks' time to file counter affidavit in the writ petition. You are appearing for whom?
Bear with me.
Taking note of the request made by the learned counsel for the respondent numbers 2 to 8. It is 4 weeks' time is hereby granted for filing affidavit, considering the urgency expressed in the matter by Mr. Chaudhary, learned counsel for the writ petitioner. This matter is directed to be listed again as a fixed item on 12th of November 2024.
Yes. My lords may consider changing it to 15th of November, my lords.
15th November, we are not working.
Then, my lords, can I please request the week thereafter, please?
Let it be preponed, my lord.
It can be preponed
Yes.
also. I can, no problem. It's a week prior also.
7th of November.
Yes.
7th.
Highly obliged.
That's the Diwali week.
Oh,
That's right, my lords. Let's get.
7th, no, Diwali ke
Then, my lords, can it be a week later, my lords? I have to come.
7th of
7th.
November.
Yes,
So,
yes.
the IA is kept pending, and the prayer made therein shall be considered at the time of hearing of this writ petition. Interim order passed earlier to continue until further notice.
Lords, may I just make a small mention? Was the letter that they are in fact relying upon, saying that there is now a vacancy, that letter has been issued by the union, which is respondent number 1. Perhaps if my lords feel it correct that their affidavit should also come on record, because eventually transfer of CMD from one company to the other, on which the petitioner is today placing reliance.
File your affidavit.
I will file my. I've already filed my affidavit for the IA. I'll file it in the main matter also.
And we'll-
Obliged.
Yes.
May it please your lordship. Lordship, we have filed one IA for implement of the new government, as the previous one has retired from his service, lordship.
Who's the new incumbent?
Lordship.
Dr. Ravi Kothari, lordship, the present chief secretary, lordship.
What is the order? Why chief secretary is required to be implemented? What is the order of the court which has not been complied with? Where is that order?
Lordship, kindly see the page number 33, lordship. Paragraph 23 and 24, the relevant portion, lordship.
Take down, heard Mr.
D. Kolita.
D. Kolita, learned counsel appearing for the applicant. Also heard Mr. A. Das, learned counsel appearing for the respondent.
Number one, your lordship.
Number one, this IA has been filed with a prayer to implead the new incumbent in the office of Chief Secretary to the Government of Assam on the ground that the earlier incumbent has demitted office on retirement. Full stop. Peruse the grounds taken in the IA. Mr. Das submits that he does not have any objection if the prayer is allowed. In view of the above, the prayer made in the IA stands allowed. The new incumbent in the office of Chief Secretary, Government of Assam, namely Sri Ravi Kota, is hereby impleaded as respondent number 2 in the connected contempt case. IA stands in the applicant to submit amended cost title in the contempt case. The contempt case stands disposed of.
Much obliged, your lordship.
But have you demanded compliance of the order from the new incumbent? Have you demanded compliance of the order from the new incumbent? Mr. Das, what kind of assistance is this? You don't seem to be applying your mind on anything. Has he demanded compliance? There's a statement there.
No, your lordship.
Then you should have pointed it out.
There is no statement, your lordship.
Then you are just standing doing nothing.
No, lordship, but he has
Huh?
to place
Is
the.
it not necessary that he should first demand compliance?
Yes, that,
Then why did you not point it out?
I'm extremely sorry, lordship.
You have not demanded compliance. Then implement of new incumbent in the office of Chief Secretary to the Government of Assam. However, from a perusal of the statement made in the IA, it appears that the applicant has not yet demanded compliance of the court order from the new incumbent before filing, so as to enable him to file the application for impediment. In view of the above, on the request of Mr. So-and-so, this IA stands disposed of on withdrawal with liberty to the applicant to approach again after demanding compliance of the order of the court from the new incumbent by following the due process of law.
Obliged.
You must demand compliance. Yes.
Same problem here. I can get it.
Manu, I have demand.
You have demanded?
Application.
Have you demanded compliance?
My lord, yes.
Where is it?
There is no statement in the application.
So it's not been annexed, but here I have.
You have not annexed, there is no statement. You want to withdraw or I'll close it? Dismiss it. What do you want?
I'll withdraw another.
All right.
Well,
Ms. So-and-so and counsel for the applicant seeks leave of this court to withdraw this IV with liberty to file afresh after rectifying the defect. Mr. S.C. Kyle and counsel for the respondent number.
All respondents.
Respondents is present and does not have any objection if the prayer is allowed. IS stands disposed of on withdrawal with liberty as prayed. You have to demand compliance or put all these things on record.
like.
My lord, the private respondents herein were to be served through newspaper notification, my lord. That could not be done, my lord. I had informed the petitioners to take the steps. Can I pray for some time, my lord? Let them try,
How
my
much
lord.
time you want?
My lord, 10 days time, my lord.
We'll give you 3 weeks.
My lord.
Expressing difficulty in establishing proper contact with his clients for taking steps for substituted service of notice upon the respondents in terms of the order dated 5/8/2024 passed by this court. Mr. Pathak has prayed for 2 weeks further time for doing the needful. Full stop. Mr. S. Bora, counsel for the
Respondent number 4.
respondent number 4 and
1, 2, 3, madam.
you are Mr.
B. Sharma, madam.
B. Sharma for 1, 2, 3 and S. Bora for 4 are present and do not have any objection if the prayer is allowed. In view of the above, 3 weeks time from today is granted to the petitioners to take steps in compliance of the order dated 5/8/2024. Let the matter be listed accordingly.
Obliged.